This is family law. These are essay statements of law for the UBE bar exam. Settlement agreement. The issue is whether the court should set aside the settlement agreement. A settlement agreement made during the divorce process is generally valid if voluntarily made. However, a settlement agreement that resulted from fraud, overreaching, or duress may be set aside if it is found to be substantially unfair. In some states, lack of independent counsel for each party may be a significant factor in support of finding the agreement substantively and procedurally unfair. A spouse who has representation may be found to have a fiduciary duty towards a spouse who does not have counsel. Adultery. The issue is whether the spouse would benefit from obtaining a divorce based on adultery. Some states have eliminated fault-based divorce. Adultery is grounds for dissolution of marriage in all states recognizing fault-based grounds. Under modern law, fault is eliminated from consideration in property distribution in many states, at least with respects to matters not related to the parties' finances. Some states restrict the use of adultery claims to determining alimony, while other states consider adultery for fault only when egregious. Consideration is given if there is disposition of assets or other financial misconduct by one spouse. Property interest in a degree. Most states hold that a professional degree or license is not property interest subject to equitable distribution after divorce. Alimony. The issue is whether the spouse is entitled to alimony. Even if a degree is not considered divisible marital property, it may be considered in the division of other marital property, as well as an alimony award for the spouse who contributed to support of the family while the degree-earning spouse was in school. For alimony, a court may consider 1. The parties' respective financial resources and needs. 2. Contributions each has made to the marital relationship, financially, or providing care within the home. And 3. The duration of the marriage. Some statutes require or allow consideration of spousal misconduct. Some specifically require consideration of one spouse's support for the other's education or training and may mandate reimbursement for such contributions or may order rehabilitative alimony. Alimony is highly discretionary. Premarital agreement. Premarital agreements must satisfy the requirements for contract formation such as capacity, voluntariness, offer, acceptance, and consideration. Mutual promises to marry and altering rights via the agreement are sufficient consideration. Most states require the agreement to be in writing and signed. A majority of states uphold premarital agreements, but courts will examine them for procedural and substantive fairness. Factors courts consider about procedural fairness of the agreement include disclosure of net worth, whether parties had independent counsel or knowingly and voluntarily waived same, timing of the agreement, bargaining power, and level of financial and legal knowledge of the parties. The agreement is considered voluntary unless there is evidence of fraud or duress. Most states do not require independent counsel, but the presence of only one party's lawyer at the execution of the agreement drafted by the same attorney could be considered coercive circumstance. Disclosure requires fair and reasonable disclosure of property and debts of the party. Full financial disclosure isn't necessarily required, but can be demanded by a party. Substantively, an agreement is unconscionable if there is a significant difference in the sophistication and resources, so that the agreement is one-sided due to inequitable bargaining power. While the UPAA looks at unconscionability at the time the agreement was executed, some states look at unconscionability at the time of enforcement. Alimony waivers are closely scrutinized. If the waiver means one party will need public assistance under the UPAA, the court may require support. A premarital agreement can change spousal ownership, powers of managing property during marriage, and creditor access to marital or community property. The issue is, what are divisible assets at divorce? Generally, in most states, equitable distribution is employed at divorce to divide property. Very few states consider all property to be divisible on divorce. Most states distinguish between marital or jointly owned property that is divided upon divorce and property separately owned, which is not distributed upon divorce and remains separately owned. In states that distinguish separate and marital property, property owned before marriage, acquired after the marriage dissolved, or acquired by gift or inheritance during marriage is individual property belonging to the spouse owning or acquiring that property. Property acquired during the marriage is presumed to be marital property. Earnings and appreciation of community property are marital property, but passive gains from separate property remain individual and separate property. Pensions and retirement benefits are also subject to distribution. However, contributions before marriage or after separation remain separate property. Property division and support provisions of a separation agreement may be invalidated, where there is evidence to support invalidation. All states authorize invalidation of a separation agreement, or a specific portion of such an agreement, based on a finding of fraud or unconscionability. Support modification. Although a support award may be modified after a divorce decree has been entered, a property division award, whether it results from a judicial decision or a divorce settlement agreement, may not be modified after a divorce decree has been entered. The distinction rests on a fundamental difference between support and property division. A support order requires payment, over what may be a long period of time, of post-divorce income, while a property division award divides assets accrued during the marriage based on the equities at the time of the divorce. Property division thus reflects an evaluation of the past, and support determination reflects an evaluation of the future. Because the future is unpredictable, courts are empowered to modify a support award to take account of changed circumstance. Because the past can be ascertained, courts are not empowered to reconsider the evaluation and modify a property division award once it has been embodied in a final judgment of divorce. Spousal and child support provisions of a divorce decree may be modified. In all states, a spousal support award may be modified based on a change in a party's circumstances. Most courts require that a change be substantial. More important, a change in circumstance that is anticipated may not serve as a basis for modification of a support order. A court may take into account legal obligations to a new spouse and/or child in determining whether there has been a change in circumstances that warrants modification of a support award. In most states, a step-parent relationship creates no legal support obligations. Common law marriage. A valid common law marriage must be recognized by all states in America, even by those that do not permit the creation of a common law marriage within their own borders. A valid common law marriage requires that at the time of the contractual agreement both parties 1. Had the capacity to marry, 2. That they held themselves out as being married, 3. That they had the present intent to be married, and 4. They cohabitated together. If one of these elements is missing, no common law marriage exists. Termination of parenting rights. The Due Process Clause of the 14th Amendment protects a biological parent's rights to raise his or her children in the manner that they see fit. Before a biological parent's parental rights may be terminated, the 14th Amendment requires a substantial showing by the petitioner that the parent has neglected his or her responsibilities to the child. Additionally, the 14th Amendment's Due Process Clause trumps any state law. Jurisdiction of custody rights. Under the UCCJEA, a child's home state has exclusive jurisdiction over custody and parental right proceedings. A child's home state is a state where the child has lived with a parent or guardian for at least 6 consecutive months before the commencement of the proceeding. Under the Uniform Child Custody Jurisdiction and Enforcement Act, the UCCJEA, jurisdiction over child custody is proper in the child's home state. The home state is defined as the jurisdiction that a child has lived in for the 6 months prior to the time of the suit. Where no home state exists, jurisdiction is proper in any state in which there is 1. Significant connections for the child and at least one parent, and 2. Substantial evidence relating to the child's custody. Child custody. In a custody case, a court will consider a child's preference as one of the many factors in determining custody. A child's wishes are instructive, but not determinative factor. In any dispute as the custody of the minor child involving a parent and a non-parent, there is a presumption that it is in the best interest of the child to be in the custody of one of the parents. In a common law jurisdiction, the family privacy doctrine states a family's home is subject to privacy, and its internal affairs generally cannot be regulated or interfered with by the government or the courts. The U.S. Constitution implies a right of privacy within the family that protects parental decisions regarding child rearing, as well as the decision whether or not to have children. State child welfare agencies will get involved if the welfare of the child is endangered. Medical emergencies with children. Statutes in all states require consent of parents to medical care for their children except in emergency situations. Parents who refuse to allow necessary medical procedures to save the life of their child may be found guilty of neglect, and a guardian may be appointed to make medical decisions. State child welfare agencies will get involved if the welfare of the child is endangered. The Uniform Marriage and Divorce Act implements the best interest of the child standard in custody disputes. Best interest of the child is determined by an examination of all relevant factors that would contribute to the well-being and welfare of the child. A parent's rights may also be terminated if they are found to be unfit. A finding of parental unfitness may result from neglect, where the child has, for example, been denied the care, guidance, or control necessary for their physical, educational, moral, or emotional well-being. Courts will not consider religion in making custody decisions based on the Establishment Clause, prevents the court from favoring one religion over another. Jurisdiction over support provisions. The Uniform Interstate Family Support Act governs subject matter jurisdiction over the interstate modification of child support. Under this act, the state that enters the original order will retain jurisdiction for modification, provided the child or one of the parties continues to live in the state. All the parties may also consent to another forum. Jurisdiction over marital residence and proceeds provision. A state may exercise personal jurisdiction over an individual by personally serving the individual in the state. The UIFSA does not apply to property division disputes. Retroactive modification of a child support obligation. A child support order cannot be modified retroactively. Federal law requires the states as a condition of child support funding to adopt rules that forbid retroactive modification of child support obligations. A child support order may be modified prospectively based on a substantial change in circumstances. A decrease in income can be a substantial change, depending on the amount of the decrease and whether the reduction in income was voluntary. Some courts refuse to modify if the income loss was voluntary. Other courts will inquiry further into the petitioner's intentions and permit modification if he acted in good faith. Modification of marital residence. A property distribution award divides assets of the marriage based on the equities of the time of divorce. Thus, a property distribution order is not subject to post-divorce modification based on a change in circumstance. The effect of bigamy. Bigamy is illegal. When a second marriage is entered into while a first marriage has not been legally terminated, the second marriage has no legal effect. Even though the most recent marriage is entitled to a presumption of validity, that presumption can be overcome by showing a prior valid marriage without formal dissolution. In some states, the putative spouse doctrine allows a purported spouse with a subjective belief in the validity of an invalid marriage to be treated as a genuine spouse for purposes of the distribution of property upon the dissolution of the invalid marriage. Other states allow distribution of purported marital assets in a proceeding to declare a marriage void, or provide for implied contract rights in property held by cohabitants. Court-ordered visitation. Parents are presumed to act in the best interests of their children and have the right to determine whether or not to allow visitation with non-parents. Courts must give special weight to a parent's objection to visitation with a non-parent before granting visitation against the parent's wishes. Premarital agreement. Under the UPAA, a premarital agreement will be enforceable unless the agreement was not entered into voluntarily or the agreement was unconscionable at the time of the signing and there was a lack of adequate disclosure. Unconscionability contemplates a large disparity in sophistication and resources that results in a one-sided agreement due to inequity in bargaining power at the time of execution. Voluntariness is based on the evaluation of a number of considerations such as timing, availability of counsel, and language skills. Courts generally have found that presenting the agreement to the spouse on the eve of the wedding and threatening to call off the agreement, if not signed, does not constitute sufficient duress to invalidate the agreement for lack of voluntariness. The UPAA does not require the assistance of independent counsel for each party, although availability of counsel can be a relevant factor. Although the UPAA does not specifically bar enforcement of provisions relating to child custody and support, Courts have refused to enforce such provisions based on public policy grounds. The best interest of the child is controlling. Property division. Formal title does not determine ownership at divorce. There is a presumption that property acquired during the marriage is marital property subject to division. The earnings of each spouse and the property acquired with those earnings or through the labor of the spouse are presumptively marital or community property. Property that was acquired before the marriage or property acquired by gift or inheritance during the marriage is separate property and is not subject to equitable distribution. A separate asset that increases in value during the marriage will be separate if the increase was due to market forces, not the labor of either spouse. If the value of a separate asset is increased through marital funds or significant labor of one or both spouse, then the portion attributable to such labor is marital property. Oh boy. Sole custody. In custody determinations, the court must exercise its sound discretion to decide as to which parent, if either, the custody of such child should be committed. Regard has to the best interests and welfare of the child and the fitness of the parent. The fact that a parent was guilty of misconduct in connection with the divorce action will be relevant only insofar as the parent's moral fitness affects the child's welfare. The best interest of the child is determined by examination of all relevant factors, including 1. The wishes of the child's parent or parents as to his custody. 2. The wishes of the child as to his custodian. 3. The interaction and interrelationship of the child with his parent or parents, his siblings, and any other person who may significantly affect the child's best interest. 4. The child's adjustment to his home, school, and community. And 5. The mental and physical health of all individuals involved. Spousal support. Spouses have a legal duty to support each other. The duty of support is generally not enforceable by a spouse directly during the marriage. However, most states provide civil remedies and criminal penalties for non-support and desertion, allowing the state to enforce family support obligations so that needy individuals do not become public charges. U.S. Constitution implies the right of privacy within the family that protects parental decisions regarding child rearing and to make medical decisions for their children. These rights may conflict with the government interest and are subject to limitation when they jeopardize the health and safety of children or have a potentially significant social burden. The Supreme Court has specifically held that a vaccination mandate is within the state's police power to protect the public health, and that a state may refuse school admission to a student who fails to receive a vaccination as mandated. Jurisdiction. Under the UCCJEA, which has been adopted by almost every state, a court has jurisdiction to make an initial child custody determination only when 1. It is the home state of the child, or had been within 6 months of the commencement of the proceeding, and if the child is absent from the form state, a parent continues to live in the form state. 2. Another state does not have such home jurisdiction, or else the home state court has declined to exercise that jurisdiction. 3. All other states having jurisdiction under either of the above provisions have declined to exercise jurisdiction on the ground that the state is the more appropriate forum to determine custody. Or 4. No court of any other state would have jurisdiction under any of the above provisions. Oh, I was going to say I think we're done, but nope, we got a little more. Alright, divorce. Subject matter jurisdiction is established over the marital states by virtue of the domicile of one of the parties within the state at the time of filing of the action, whether or not the parties live there as a couple. Domicile generally requires both physical presence in the state and the intent to make the state a permanent home. Some states impose a jurisdictional requirement that one of the parties must have resided in the state for a specified period of time prior to the filing of the divorce action. Personal jurisdiction over the defendant is not required for a court to enter a divorce decree. Physical presence or personal jurisdiction over a party or a child is neither necessary nor sufficient for a state to make a child custody determination. Property division jurisdiction. Personal jurisdiction over the defendant is necessary for the court to enter or enforce any decrees in personam, including the entry of orders imposing support obligations, orders relating to out-of-state property, or the institution of contempt proceedings to enforce such orders. In addition to proper service of process, in order for the court to enter an in personam order, the defendant's spouse must have sufficient minimum contacts with the state, such that entry of such an order does not offend traditional notions of fair play and substantial justice. Fault-based divorce. Fault grounds still recognized in many states include desertion, adultery, impotence, cruelty, imprisonment, habitual intoxication, or drug addiction. Cruelty as a ground for divorce consists of a pattern of physical abuse committed by one spouse upon the other, which causes physical injury. However, a single egregious act of violence may be sufficient. Subject matter. Priority in competing child support orders. All states have adopted the Uniform Interstate Family Support Act to facilitate enforcement of support orders across state lines, making it easier to obtain jurisdiction over an obliger who moves. The UIFSA establishes priority among competing child support orders. The state court may exercise jurisdiction to establish a support order after a pleading is filed in another state, only if this state is the home state of the child or jurisdiction in the other state has been timely challenged, or jurisdiction in the other state has been timely challenged. As long as the requirements for personal jurisdiction are met, the UIFSA does not preclude a state from issuing a support order when another state is the child's home state. That concludes family law.